Simulation Exercise 3 Arbitration. Mrs. Vega Constructions Limited contractor entered into an agreement with HMDA for construction of an elevated expressway between LB Nagar Crossroads Junction to Rajiv Gandhi International Airport, Shamshabad. The project will ease the traffic hassles of airport commuters and reduce travel time by 50%. The agreement was entered into by the parties on 12/6/2018. The agreement contains an arbitration clause which provides all disputes shall be resolved by arbitration, the place of arbitration being Hyderabad. The details of the project are as follows. Value of work is 2,11,32,84,000. The work has to be completed within a period of 24 months. If the execution of the work is delayed by the conduct of any party, the defaulting party is liable to pay to the other party liquidated damages amounting to a sum of 1% of the total value of the work. The contractor mobilized men, material and equipment in order to complete the work within stipulated time. When the work was in progress, the HMDA, via its letter dated 21/6/2019, asked the contractor to stop work due to pandemic COVID-19 that had struck the country. By the second week of June 2019, work to the tune of rupees 98 crores 50 lakhs 24,000 98 50 24,000 had been completed by the contractor. The contractor was left with no option but to suspend the work, leaving all material and equipment idle at the site. HMDA did not intimate the contractor the likely time for restoring the work even after the notification of unlock rules by Government of India, which permitted some construction activity in the now non-COVID-19 hotspots starting 20th April 2020. The area governed by the contractor falls outside COVID-19 hotspots. The contractor, via its letter 2520, intimated to the HMDA about his intention to carry out another work for another party, but the authorities denied permission to do so. After a period of 2 months from receiving the report, HMDA gave clearance to the contractor for the execution of the contract. The contractor completed the project by the end of October 2021. The contractor claimed additional damages by way of loss incurred by keeping machinery comprising 10 trucks and 2 cranes idle, for which no logbook was maintained by the contractor. But the contractor produced the receipts of charges paid towards servicing of the vehicles by the garage company on different dates on different vehicles. The contractor raised a dispute claiming liquidated damages under the contract, citing delay on the part of HMDA. A further claim was made for additional damage for keeping the trucks idle and claimed a sum of 1 crore 24 lakhs from the HMDA. Sole arbitrator has been appointed by the parties to arbitrate the dispute, conduct the arbitration and draft an award. Next, exercise 4 is based on the same case, conciliation. For the above problem, conciliate between the parties and draft a conciliation agreement after a successful conciliation. This is 3 and 4. Let's see the solution. Hyderabad Arbitration Award Memorial. Sole Arbitrator, Office of VVS, that's the student name. In the matter of Mrs. Vega Construction Private Limited, Contractor Hyderabad, the complainant, versus HMDA, Hyderabad Metropolitan Development Authority, the respondent. Memorial prepared by the student, roll number the award. Part 1. The parties. The complainant is Mrs. Vega Construction Private Limited, Hyderabad. The respondent is Mrs. HMDA, Hyderabad Metropolitan Development Authority, Hyderabad. Second part. Arbitrator. The complaint was filed with the court Senior Civil Judge, City Civil Court, Commercial Court, City Court Complex, Hyderabad, by the complainant against the respondent listed above. The court verified the complainant and the complaint together with the annexures to the complaint and satisfied the formal requirement of the contract and Indian Contract Act and Arbitration and Conciliation Act 1996. In accordance with the rules, clauses of contract, and rules framed under the Arbitration and Conciliation Act 1996, the court appointed me as the sole arbitrator for adjudicating upon the dispute. The parties were notified about the appointment of arbitrator on so-and-so date. The panel of arbitrators from which my name was chosen by the court has complied with the statement of acceptance and declaration of the impartiality and independence as required by the Act and rules. The arbitration proceedings commenced on so-and-so date 2023. In accordance with the rules, para so-and-so, the respondent has notified by me about the commencement of the arbitration proceedings and the due date for filing their response through their legal representatives. The respondent filed the response to the complaint on so-and-so date within the stipulated time period of so many days granted by the panel vide its notice dated so-and-so and so-and-so 23. The language of the arbitral proceedings has been agreed to be in English. In the facts and circumstances, in-person hearing has not been considered necessary for deciding the complaint and the consequences on the basis of the statements and documents submitted on record. The present award is passed. The present award is passed within the period of 60 days from the date of commencement of the arbitration proceedings as per para so-and-so of the rules. Part 3. Subject matter of contract dispute and hence arbitration. Number 1. The contract for construction of elevated expressway between LB Nagar X Roads to Rajiv Gandhi International Airport, Shamshabad. Second, the value of work is 211,32,8430. Third, the work has to be completed within a period of 24 months from June 2018 to June 2020. Time is the essence clause. Number 4, the execution of the work is delayed. If the execution of the work is delayed by the conduct of any party, the defaulting party is liable to pay to the other party liquidated damages amounting to a sum of 1% of the total value of work, that is 211,32,840. Point number 4. Terms of arbitration agreement between the parties. The contract was signed on and entered into with effect from 12/6/2018 with an arbitration clause which provides that all disputes shall be resolved by arbitration only. The arbitrator being chosen or appointed by the judge, City Commercial Court in City Civil Court, Hyderabad, and the place of arbitration or seat of arbitration shall be Hyderabad, and the laws and rules applicable will be those applicable at Hyderabad. Point number 5. Summary of facts, proceedings, how and what of dispute. Number 1. The contractor mobilized money, men, material and machinery in order to complete the work within the stipulated time. Well, the work was in progress and completed to the tune of 98,50,2430, that is by the second week of June 2019. Point number 2. 1 year completed in time and 50% of time over and 46.61% of work in value terms accomplished. So both are almost similarly in line. Point number 3. HMDA, by its letter dated 21/6/2019, asked the contractor to stop work due to pandemic COVID-19 lockdown ordered by the Government of India. Point number 6. Cause of action and source of dispute. Origin of dispute. 1. HMDA, by its letter dated 21/6/2019, asked the contractor to stop work due to the pandemic COVID-19 lockdown as ordered by Government of India. The contractor was left with no option but to suspend the work, leaving all the machinery and equipment lying idle at the site. HMDA did not intimate the contractor the likely time for restraining the work even after the notification of unlock rules by Government of India, which permitted some activity in the non-COVID hotspot starting 20th April 2020. The area of operation of the contractor falls outside the COVID hotspots. Point number 7. Cause of action number 2. The contractor, via letter 25/2020, intimated to the HMDA about the intention to carry out another work from a third party, but the authorities denied permission to do so. Point number 8, cause of action number 3. After a period of 2 more months from the date of receiving the Government of India report in June 2020, HMDA gave clearance to the contractor for the execution of contract, that is, resumption of work on the contract. The contractor completed the project by the end of October 2021 with a total delay of 1 year 4 months, July 2020 to October 2021. Summary of issues and respective position of the parties. The contractor claimed liquidated damages as per contract terms, citing delay on the part of HMDA in allowing him to resume work on the contract. In COVID-19, an act of God, and if so, who should make good the loss and who will formulate the rules for doing so? The contractor claimed additional damages by way of loss incurred for keeping the machinery comprising of 10 trucks and 2 cranes idle. The contractor did not maintain any logbook in support of the above claim. He produced receipts of charges paid for parking, servicing of vehicles by the garage company on different dates for different vehicles. Claim amount for additional damages is 124,000,000, 124 lakhs. For MORTH circular number COVID-19/Roadmap/JSH/2020 Government of India, Ministry of Road Transport and Highway Transport, Transport Bhavan, New Delhi, 110001. Subject: Atmanirbhar Bharat Relief for Contractors, Developers of Road Sector, dated 18th May 2020. The following measures are hereby notified for providing relief to contractors, developers, or concessionaires of road sector from the impact of COVID subsequent lockdown and other measures taken to prevent spread of COVID. Para C. MORTH letter so-and-so, dated 25/3/2020, conveyed that the lockdown period and the subsequent prevailing condition of low traffic due to COVID-19 epidemic outbreak may be treated as force majeure of the concession or contract of agreement. Para 1, Clause 2, reimbursement of 75% of administrative expenses to be calculated for the period 26th March 2020 to 19th April 2020. Para 2, Clause 3, reimbursement of up to 50% of administrative expenses to be calculated for the period 20th April 2020 and later for slow resumption of normalcy. Next, SC decision on relevant issues. 1. Limitation. Supreme Court suo motu took up the issue of extension of limitation by order 23 March 2020 SC online SC 343. Ordered that a period of limitation in all such record proceedings, whether condonable or not, shall stand extended with effect from 15th March 2020 till further orders. Power under Article 142 read with Article 141 Government Constitution of India. Next, impossibility of performance is covered under Section 56 of Indian Contract Act 1892. Impact of contractual timelines by COVID-19 lockdown as impossibility to function situation. Government of India Circular dated 19/2/2020 on force majeure clause regarding Manual of Procurement of Government of India 2017. New communication issued by Government of India on 18/5/2020 on the same subject, and waiver of charges are payable by contractors regarding highways. SC Energy Watchdog CERC 2017-14-SCC-80 and Delhi HC Halliburton Offshore Services versus Vedanta Limited, OMP 8 of 2020. Number 5. Government of India notification dated 19/2/2020 says a force majeure means extraordinary event beyond human control, such as an event described as an act of God, and like natural calamity, and events like war, strike, riots, crimes, and negligence. And FM clause, force majeure clause in a contract, frees both the parties from contractual liability and obligation when prevented by such events from fulfilling their obligations under the contract, as FM clause suspends it for the duration of the FM. Full operability of the contract is hindered by orders of the national and state governments, that is, by the circumstances beyond the control of petitioner. In Halliburton Offshore and plus SC in Energy Watchdog decision regarding force majeure, para 56, there is no doubt that COVID-19 is a force majeure event. SC principles on force majeure in Energy Watchdog was a CERC case 2017-14-SCC-80. A force majeure would operate as a part of the contract as a contingency under Section 32 of the Indian Contract Act 1872. The doctrine of frustration could be invoked by a party as per Section 56 Indian Contract Act, which would include impracticability or uselessness, keeping up in mind the object of the contract. If an event or change of circumstances promised finds it impossible to do the act which he had promised, express terms of contract cannot be ignored on equity. Risks have to be borne by both parties. Performance is not discharged by it if it is onerous. Alteration of circumstances is not a frustration. Doctrine of frustration has to be applied narrowly by the courts. A mere rise in cost or expense does not lead to frustration. If alteration of performance exists, FM will not apply. Terms of contract, knowledge, expectation, assumptions, nature of supervening event to be considered. If contract has inherent risks, FM not to be invoked unless there is break in identity between the contract as envisioned originally and the performance in the altered circumstances, FM not to apply. All the above in Delhi High Court, MEP Infra versus South Delhi Municipal Corporation, WPC 2241/2020, decided 12/6/2020. Maitra Guha Builders Company versus ONGC SC held employer contributed to delay, no penalty or liquidated damages disguised as penalty. SC in Karnataka versus Sri Rameshwara Rice Mills, para 7. Party to agreement cannot be an arbitrator in his own cause. Whether a delay caused by whom is to be determined objectively and by third party only, like arbitrator, and quantum of liquidated damages be calculated as per contract terms. 7. JG Engineers Private Limited versus Union of India 2011-5-SCC-758, para. Contract clause does not attract finality to the question as to whether the contractor has failed to complete the work or portion of work within the agreed time schedule, whether the contract was prevented by reasons beyond his control or by the action or commission of the respondents, and who is responsible for the delay. SC in Mitra Guha versus ONGC, if further adjudicates under claims is allowed, it will render the agreement meaningless and the redundant. Remedy shall be the ordinary course of law and not arbitration. Scope of finality is only quantification of liquidated damages. The same is consequential to and distinct from the primary power of adjudicating the loss of the party responsible for such breach, and further the employer cannot be an absolute arbiter in his own cause. Second, the SC has not considered that even if the claim against the levy of liquidated damages is not referred to by the arbitrator, the contractor may refer other claims, such as escalation on account of delay caused by the employer, to the arbitrator. In such a case, the arbitrator will be required to determine the party responsible for delay in completion of the contract. In the case Bansal Brothers case, Union of India versus Bansal Brothers, Delhi High Court, 31/1/2022, as per Section 19 of the ACA Arbitration Act, sole arbitrator can determine the admissibility, relevance, materiality, and weightage of any evidence, no violation of natural justice, and award in accordance with the public policy of India. It was obligation on the arbitrator to take into account the terms of contract and trade usages applicable to the transaction in accordance with the mandate of Section 28 Clause 3 of the Act, and for non-compliance of the aforesaid mandate, under Section 74, can receive a reasonable compensation, such liquidated amount, and if it is genuine, liquidated damages can be awarded not exceeding the amount so stated in the contract as LD, or penalty in the upper limit beyond which the court cannot grant reasonable compensation. Reasonable compensation will be fixed on well-known principles that are applied by law of contract, which found in section 79 ICA. Where it is possible to prove that actual damage or loss, such proof is not dispensed with. The section applies to both the plaintiff and defendant equally. Delhi High Court in the case Paints Private Limited versus Union of India, Manu DG/0648/2011. In case a contract was not performed and there was breach thereof by the petitioner, it was for the respondent to prove the loss suffered because of such breach. It is mere res integra that liquidated damages is not a debt and requires adjudication by court or arbitrator. Arbitral tribunal has jurisdiction to decide as to which party was responsible for delay. Breach of contractor is equal to at not maintaining the progress as per clause and failing to complete the work by contract date. Failing to complete the work, unjust enrichment cannot be countenanced and has to be eschewed. No liquidated damages when no loss is suffered. Analysis of the arbitrator and findings as to the facts applicability of law to the facts. 1. Timeline of the project with different events and its interpretation. 2. Start of the project is equal to date of agreement June 2018. 3. Stoppage of work due to pandemic, an act of God, force majeure event June 2019. Time completed till then 50% of work completed, half time hour work completed till then 46.6%, moderately less. Permission to start work by lifting restrictions by Government of India April 2020. Contractor willing to start using the machinery and men on another site or contract, that is opportunity cost, start date May 2020. Contract given go ahead to restart the work by HMDA in June 2020. The period lost due to pandemic only June 2019 to April 2020. Period of loss due to lack of administrative clearance attributable to the inaction on the part of HMDA May 2020 to June 2020. Period of opportunity cost for the contractor as he was denied permission to use his assets for another project May 2020 to June 2020. Completion of the work October 2021. Delay in completion of the work overall June 2020 to October 2021, that is 17 months. Delay due to COVID-19 lockdown June 2019 to 2020, 12 months. Force majeure period 100% affected. Delay beyond it occasioned by the COVID period loss is 5 months. Delay occasioned by lack of administrative clearance 2 months. Delay that caused opportunity loss of 3 months. The balance. Next, period for which HMDA is solely responsible for the loss of the contractor on account of opportunity cost is 3 months. Period for which force majeure applies 12 months. Operative part containing award or decision. We award liquidated damages to the extent of 75% of actual cost of parking charges and repair charges of the vehicles as evidenced by the garage receipts for 12 months, being the period of delay caused by Government of India HMDA order and COVID-19 pandemic restrictions, subject to the limit of liquidated damages written in the contract. We award liquidated damages of 100% loss caused by inaction of HMDA with opportunity cost loss calculated 100% of actual repair and parking charges for 2 months, and loss of business and profit calculated at 10% of the contract value of alternative work, that is permission denied by HMDA. We direct each party to bear their own costs. Reasons for the decision. The contract is affected by 2 events, force majeure and the inaction or delayed action of HMDA. For force majeure, we follow MOSTH circular. For HMDA delayed action, HMDA is held liable to pay for the loss on account of opportunity cost. For principles of equity, Uberima Fide, Government of India circular, Supreme Court and High Court rulings on various issues. Signed. Conciliation on the same case. The agreement made this day between so-and-so, Vega Construction, Hyderabad on one part, HMDA Hyderabad on the other part, whereas certain disputes and differences have arisen and subsisted between the aforesaid parties relating to the contract for construction of elevated expressway between LB Nagar Crossroads and Rajiv Gandhi International Airport, Shamshabad. Value of the work 2/11/32/84/30, time period 24 months, and wherein the parties agree to submit their disputes for an amicable settlement in accordance with the ICADR Conciliation Rules 1996. Now the parties hereby agree as follows. 1. The parties agree to resolve their dispute by conciliation in accordance with ICADR Conciliation Rules 1996. Sole arbitrator is appointed by ICADR. The conciliation shall be administered by the ICADR in accordance with the ICADR Conciliation Rules. The place of conciliation shall be Hyderabad. The parties have agreed to the following resolution of the disputes listed as below. Dispute number 1. The contract was signed in June 2018 to be completed by June 2020, 24 months, but it was actually completed and handed over by the October 2021 with a delay of 1 year, 4 months. Resolution. Both the parties have agreed to the facts as given above. There is no difference in opinion on the dates of the schedule and actual dates of the contract completion. Dispute 2. The cause for delay on account of two supervening events, the first being the COVID-19 lockdown force majeure event lasting from 21/6/2019 to 24/2020, on which date Government of India allowed work to be resumed in non-COVID hotspots. Resolution. Both the parties have agreed that the force majeure guidelines of Government of India shall apply for the above period of postponement of work 21/6/2019 to 24/2020. The relevant MORTH circular on COVID-19 roadmap JSH 2020 by Government of India dated 18/5/2020 is agreed to be the basis for resolution of this dispute for the period. As per the above circular, it is agreed that the period will be treated as res nullius, are not counted for contract period, and no penalty will be levied on the contractor for delay during the period during which no work could be carried out. As the contractor has genuinely faced expenses not contributing to the completion of the contract by way of parking and repair charges of his vehicles, an amount equivalent to 75% of the actual expenses towards parking and repair of transport vehicles and earth moving equipment will be reimbursed by HMDA to the contractor. Dispute number 3. Government of India flagged off limited resumption of work in non-COVID hotspots on 24/2020, but HMDA delayed the onward permission to contractor till 20th June 2020, 2 months from 24/2020. Resolution. HMDA is responsible for the loss of 2 months for work time and which forms part of the total delay and hence is liable under the liquidated damages clause to the contractor and hence has to bear the total cost of the parking and repair of vehicles for the period of 2 months 24/2020 to 20 June 2020, calculated at 100% of the actuals, subject to the total limit of liquidated damages mentioned in the contract. Dispute 4. The Government of India allowed limited resumption of work on 24/2020. The HMDA was not quick on the take to permit or instruct the contractor to resume work. The contractor on 25/2020 wrote to HMDA to allow it to use its assets for another third party work till HMDA makes up its mind. HMDA refused permission and was cause for loss of business and profit till 26/2020. It is 1 month 18 days. Resolution. The parties hotly contested this claim and finally agreed that HMDA will make good 10% of the expected profits for opportunity loss for the value of work that the contractor could have undertaken for third party from 25/20 to 26/2020 as loss of expected profits. Dispute number 5. The contractor claimed 1 crore 24 lakhs in addition to the expenses or losses mentioned above on the LD. Resolution. In view of the resolution of disputes 2 to 4 on generous disposition of the HMDA, the contractor has agreed to withdraw the said claim on a without prejudice basis. It was agreed that this claim and its withdrawal would not go to or used to discredit the contractor in any way or affect his other rights and responsibilities under any other act, rules or contract. In witness whereof, this agreement has been signed on 8th day of February in Hyderabad.